Hello, everyone, and welcome to the IFST webinar, Unfit or Unsafe, 10 years on, lessons learned from the horsemeat crisis, organized by the Food Regulatory Special Interest Group of the IFST. My name is Bruce Lambourne. I'm a director of a consultancy business, Food Technology and Integrity Consulting. I'm a food technologist and management consultant by training, with 30 years of experience within the food sector, both internationally and within the UK, across a broad range of categories. I've been fortunate to have worked with the FSA, DEFRA, and Lab of the Government Chemists during the horsemeat crisis to develop industry guidance by quantifying the effect of different hygiene regimes on DNA carryover in multi-species plants. And I'm both a fellow of IFST and Vice Chair of the Food Regulatory SIG. The food industry faces an era of unprecedented risk due to climate change and global conflict affecting global supply chains, compounded by inflationary pressure. This impacts on both food security, authenticity, and specification compliance due to pressures businesses are under to maintain margin. On the 10th anniversary of the horsemeat incident, a major meat fraud incident occurred, which is still under investigation. The webinar aims to educate members on the purpose of general food law, how it came about, the meaning of key principles, and how this applies to businesses. The enforcement perspective and draws on some case law examples to illustrate how the key principles are practically applied and what businesses can do via due diligence to defend themselves. Next slide, please. The webinar is being recorded and will be uploaded to the IFST's webinar hub. Feel free to make comments and ask questions throughout the webinar using the Q&A button at the bottom of your screen. You can also upvote other people's questions by clicking the like button next to their question. There will be a Q&A session after the presentation where we will respond to as many of these questions as possible. Our speakers today are Richard Hyde, Professor of Law, Regulation and Governance at the University of Nottingham, and Nicholas Smith, Partner at Squire Patton Blogs. Richard joined the School of Law at the University of Nottingham as an assistant professor in January 2013 and became an associate professor in August 2016 and has been a professor of law, regulation and governance since August 2019. He was deputy head of school, education and student experience between 2020 and July 23. He's previously lectured at Northumbria University, has an LLB honours from the University of Durham and an LLM in International Criminal Justice and Armed Conflict, and an MA in Social, Legal and Criminological Research Methods from the University of Nottingham. He's currently the co-director of undergraduate studies in the School of Law and the academic director of the university's Pathways to Law project, which is funded by the Sutton Trust and the Legal Education Foundation, and seeks to encourage sixth form students to aspire to a career in law. In 2015, he was awarded a University of Nottingham Daring Award for outstanding achievements in enhancing the student learning experience. Education Academy. He currently teaches courses concerning tort, contract, and consumer law in the School of Law and Food Regulation in Biosciences. Nicholas Smith specializes in regulatory compliance, and her expertise covers food and feed law and safety and recall, including food contact materials. She provides training to clients on food law requirements, including in relation to allergen laws, product recalls, and Brexit-related labeling and compliance issues. She's provided training to a global catering company on EU food information for consumers regulation and food safety laws, and recently to members of the Food and Drink Federation on the legal impacts of food safety culture. She advised on reporting obligations and due diligence procedures following a meat scandal, and has advised on the requirements for notification and recall of food and drink products, and regularly advises on labeling requirements, including Natasha's Law, origin indications, health and nutrition claims, and food business operator details in the EU and the UK post-Brexit. She's also advised on potential enforcement action by local authorities for various breaches of food laws. Nicola is heavily involved with Squire, Pattern, Blogs, EU and UK Food Special Interest Group, and is a professional affiliate member of the Food and Drug Federation. For more information on our speakers' biographies, please look at the IFST website. So with that, I'll hand over to Richard.
Morning, everybody, and thank you for coming along today. As Bruce said, I'm Richard Hyde. I'm Professor of Law, Regulation and Governance here at the University of Nottingham. It's nice to be back talking to the IFST group here. Last time I did, I think it was in person and pre-COVID. So it's lovely to be back. My job today is to kind of take you up to the present day on the evolution and the role of food law. There's a little bit of overlap between what myself and Nicola will say, but hopefully it'll be useful and interesting as to how it goes. So horsemeat was obviously a huge problem for food manufacturers, for consumers. And as Bruce nicely laid out in the introduction, we probably shouldn't expect it to be the last. But of course, as we know, it wasn't the first. And adulteration of products is the genesis of food law. We know that in the 17th century, the 18th century, and the 19th century, there was significant concern about additions of foreign substances into foods, causing them both to become dangerous, but also to be kind of less valuable than what the consumers thought they were buying. And we see that the famous treatise on adulterations of food and culinary poisons, or death in the pot, as people sometimes call it. Frederick Ackham points out that if you rob somebody on the highway, you go and are executed. But if you poison food through adulteration, you don't get punished. And that was seen as a problem. And we know throughout the 19th century, there was a huge amount of concern around adulteration of food, leading to the Hazell Report and parliamentary committee looking into food adulteration, which concluded that adulteration was widespread. One good example of where adulteration caused serious harm was in the Bradford sweet poisoning in 1858. Sugar was very expensive, so sweet manufacturers didn't want to use tons of sugar in making their sweets. So they substituted sugar for DAF, powdered gypsum. One day, the person who was doing this dispatched someone to go and pick up the powdered gypsum from a chemist. The chemist was ill. There was a trainee on duty, was told by the ill chemist from his bed, go and pick up the powdered gypsum from and described where it was. Unfortunately, they didn't pick up and provide powdered gypsum, which is bad but not going to kill you. Instead, they provided arsenic trioxide. So they mixed their sweets with arsenic trioxide. 21 people died, 200 became ill, and frankly, when you look at the amount of arsenic that was in the sweets, it's a miracle that only 21 died. Following the Bradford sweets poisoning, prosecutions were brought against both the pharmacists and the sweet manufacturers. but those prosecutions for manslaughter failed. This led to a push alongside the House report and the things that were said in Parliament. This led to a push to reform regulation, to create specific food law. And the Food and Drink Act 1860 was introduced, where it made it a specific offence to sell adulterated food, but it failed. It failed for, as Nicola will talk about later in today's climate, because there was a real challenge around enforcement. The challenge around enforcement in 1860 was basically lack of scientific knowledge. There weren't enough qualified people to serve as analysts of the food to determine whether it had been adulterated. So it was very, it was on the books, but wasn't really enforced. Following the 1860 Act, the 1875 Act, Sale of Food and Drugs Act, 1875, created an offence that to sell food that was not of the nature, substance, or quality demanded. And that remains in force through various bits of food law up until the Food Safety Act 1990. And there were special provisions introduced on the adulteration of particular products, for example, milk, sort of 19th century as well. As well as adulteration, there was concern about food being safe, and particularly ensuring that food that was sold, even if it was what it said it was safe for consumers. And then there was obviously an introduction of law that said that food should be fit for human consumption and not injurious to health. An example of that, obviously coming through the years, in the Food Safety Act 1990, sections 7 and 8. Obviously that changed with the introduction of EU food law in 2002 and onwards. But the Food Safety Act 1990, food has to be fit for human consumption, food has to be not injurious to health, food has to be the nature, substance, and quality demanded. Obviously, the EU is joined in the mid-1970s and becomes an important source of food law. But EU food law was shown to be kind of unfit for purpose during the 1990s, particularly around BSE, but generally was thought not to be smart enough regulation. And a large amount of new food law was introduced in the decade from 2000 to, well, just over a decade, 2000 to about 2012, including, as we know, the General Food Law Regulation 178/2002, which contains much of the basis of, we're talking about safety here. And there's also a lot of law introduced around enforcement as well, and how that's got to be done. And institutional frameworks are created. So what's the current law? Well, food, we all know what food is, but it's substance, processed, partially processed, unprocessed, intended to be or reasonably expected to be ingested by humans. And so we're including everything from drinks to vegetables to highly processed lasagnas, whatever. It's all food, and includes chewing gum as well, even if we're not expecting it to be ingested. The law places responsibilities on the food business operator, and that is the natural legal people or persons responsible for ensuring the requirements of food law are met. And you can be a food business operator even if you're not kind of the business that is running the show. The manager of a particular plant might be seen as a food business operator. And similarly, you can be a food business operator when your establishment is closed. This is kind of obvious. You don't have to be preparing and serving food on the premises to be a food business operator. So if your pub's overrun by rats at night, you can't get out of the people saying that this is improper, in breach of the food hygiene regulations, by saying, well, we're not a food business operator because we're not operating a food business at that moment. And of course, you can have more than one food business operator on a particular premises. As we're all aware, there's a general safety requirement in the General Food Safety Regulations, Regulation 178/2002. Article 14 says the food placed on the market has to be safe. That is a general catch-all term, but it then goes on to define what safe means. Safe being must not be injurious to health, must not be unfit for human consumption. And this reflects some of the things that were in UK food law before the introduction of the General Food Law regulations. And it comes about because there was negotiation, and those categories of injurious to health, unfit for human consumption, are seen as capturing what we want to say about food. Note that unfit for human consumption is further defined as it must not be putrefied, deteriorated, or decayed, or contaminated. In thinking about injurious to health, we don't only think about injurious to health in the immediate post-consumption moments. So obviously something will be injurious to health if it is microbiologically unsafe and I eat it and I then suffer gastroenteritis. That's injurious to health. But also we've got to think about the long-term effects of food being consumed on the person consuming it. And not only are we talking about long-term effects on the person, but also subsequent generations. So if we've got a mutagen, if it might potentially have problems for future unborn children, that food can still be seen as injurious to health. And we've also got to take into account cumulative effects. So if food is safe if consumed in small amounts, but it's reasonably foreseeable that it will be consumed in enough amount that will prove toxic, then you've got to say that that's injurious to health and it's not safe, can't be placed on the market. In determining whether something is safe, we take into account the normal use of the food and of the instructions that are given. So the fact that you sell food that has microbiological contamination, if the normal use, according to the instructions, is to cook it for sufficiently long and at sufficiently high a temperature to destroy those microbes, then it's safe. If the fact that someone eats it raw when you would not expect people to eat it raw and the instructions make clear that you shouldn't eat it raw, that doesn't mean it's unsafe. The other thing to bear in mind is consumers who are vulnerable. If you are manufacturing food products for a particular group of consumers who might be particularly susceptible to particular consequences, then you've got to make sure your food is safe for them. And a good example of this, of course, is baby food. If you're manufacturing baby food, babies having less developed immune systems, then you need to ensure that you manufacture it so it's safe that those babies eat it. Just a quick comment on unfit for human consumption. There's a Scottish case from 1951 that deals with the previous wording for unfit for human consumption, unfit for the food of man. And the judge there says, you've got to look in all the circumstances. You've got to look in a practical, common sense way. Is this unfit for human consumption? Would a person seeing it think, no, I'm not eating that. That's not fit for human consumption. Not about them being picky. but it's absolutely unfit for human consumption. And the examples that we get of putrefied and decayed, etc., those things are obvious situations where it would be unfit for human consumption. It is likely that if you're selling food that is putrefied or decayed, you might be in breach of other regulatory requirements as well, potentially under the Food Information Consumers Regulations. But if it's putrefied or decayed, can't place it on the market because it's unfit for human consumption. And that's a practical, common sense approach to take. And it's been approved that unfit for the food of man means the same thing as unfit for human consumption. And the Kyle and Laird test has been used in various cases since. Contamination, what does that mean? Well, it can be physical, it can be chemical, it can be microbiological. Coming back to the Food Safety Act 1990, that requirement that was introduced in the 1875 Act remains in place under Section 14. You have got to sell food that is of the nature, substance, or quality demanded by the purchaser. If it's not of the nature, substance, or quality demanded by the purchaser, then it's an offence. And we see in lots of examples where food that is adulterated, like in the horsemeat situation, is said not to be of the nature, substance, or quality demanded. One example comes from a large Italian restaurant chain that was fairly recently prosecuted for selling a lobster pasta. This lobster pasta had a minimal amount of lobster in it. Instead, it had reconstituted white fish mixed with a small amount of lobster and was put in a shape that made it look like a lobster. That was said to be food that was not of the nature, substance, or quality demanded, because the consumer would expect, when they're being sold lobster pasta, that they would have lobster in it, a large amount of lobster. Similarly, there's a case around the selling of beef mince, that where the beef was mixed with pork mince, that was said to be adulterated and not of the nature, substance, or quality demanded. As well as food law, of course, the general criminal law has things to say about food fraud. And where you dishonestly make a false representation, a representation that this is beef when it is in fact horsemeat, or that this is lobster when in fact it is white fish, you can potentially be caught by the Fraud Act 2006. The Fraud Act 2006 criminalises making a false representation if you intend by your representation to make a gain. So, for example, if you are selling things for more than you could have sold them for if you were truthful about their contents, the general criminal law can step in and be potentially liable for fraud. Obviously, as well as looking at the past, it's important to look at the future. And we know that all the reasons that Bruce talked about in the introduction mean that we are not going to go through our professional lives without seeing more situations where food is adulterated, where food is sold as something that it is not. And one of the things that we have to think about is how can we use what we're doing in enforcement, which Nicola will talk about, to reduce those risks, reduce the risks of safety to the consumers, but also reduce the risks of consumers being misled and left out of pocket because of these different things that are said. We also have to deal with two other things that have kind of happened in the past 10 years since the horsemeat scandal. Brexit. Brexit has the potential to alter the food law landscape in the UK, particularly in Great Britain, given the Northern Ireland Protocol. As I see it at the moment, there's not a great deal of enthusiasm to alter the law as it relates to safety, or indeed to standards, nature, substance, or quality. But it's something to keep an eye on. And certainly when we're thinking about potential changes to the law, we need to bear in mind both the need to trade across borders, but also the need to ensure that any changes are for the benefit of consumers and don't mean that it makes it easier for any of these scandals to happen in future. The other thing to mention is COVID, of course. COVID led to a lot of changes in the way that both food manufacture is done and also in inspection and enforcement. And we have to bear in mind that the changes provide us with a chance to really think about how our law works, how our regulation works, how our enforcement works, in order to make sure that we don't have another or don't have problems of fraud and scandal in the future. And with that, thank you very much, everybody. I'll hand you over to Nicola for her session, and I will see you all for the questions. I hope that that was interesting. Really looking forward to having a discussion at the end. Thank you.
Thanks very much, Richard. And I am just going to share my slides. Good morning, everybody. It's very nice to see you all. I'm going to cover some of the same ground as Richard today, but focus on some slightly different aspects. And what I would say is that when I started to really focus on food law and what it means for clients, it was around 10 years ago. And I think that the horsemeat scandal really shone a light on whether the legal framework in the EU and the UK was fit for purpose in terms of consumers being able to trust what it says on the tin. So that's the context in which I've prepared this presentation today. Up on screen now, there's the obligatory slide about Squire Patton Boggs and who we are and where we are. And you'll be pleased to know I'm not going to spend too much time talking about that. But I did just want to flag that we have boots on the ground locally as well as nationally and globally. And that really sort of brings home to me in the context of horsemeat how important it is to take into account those global supply chains when you are looking at authenticity and whether food that's in the supply chain is unsafe or unfit for human consumption. So against that background, I really wanted to cover three main areas today. I'm going to touch on the legal framework that Richard has just explained, perhaps with a bit more of a focus on what the difference is between unfit and unsafe food, before looking at what the enforcement regime looks like post horsemeat and 10 years on from horsemeat, because essentially what the law says and what it covers is really only as good as the enforcement that takes place to ensure that people that are not complying do so in future and to send a message to those that aren't complying, before finishing on how I think that is impacting on food business operators. So to start with, as Richard said, the general food law regulation really sets out at EU level what the general principles are of food law, the overarching obligation that you can't place food on the market if it's unsafe, and goes on to say that food shall be deemed to be unsafe if it's considered to be injurious to health or unfit for human consumption. And the use of that word "or" there suggests that food can be safe, or at least can be not injurious to health, but still unfit for human consumption and therefore considered unsafe within the meaning of the legislation. And the regulation then goes on to explain what needs to be taken into account in looking at unfitness, which Richard covered in his presentation. But essentially, I think it's worth bearing in mind that in practice, food is generally considered to be unfit as opposed to unsafe, as opposed to injurious to health. If it has, for example, mould, which perhaps makes it unattractive and signifies deterioration, but doesn't necessarily cause an adverse health effect. And we can see that when we look at something like the Food Standards Agency's rapid risk assessment of edible insects that were available on the UK market in September last year, where in that risk assessment, the FSA said that high levels of aerobic counts, lactic acid bacteria, yeasts and moulds are generally associated with food spoilage and food being unfit for consumption. So they're the kinds of issues that, as well as the sort of broad legislation outlines of contamination and putrefaction, deterioration and decay, might indicate that a food is unfit and therefore unsafe within the meaning of the legislation. And this is certainly confirmed by the EU Standing Committee on Food Chain and Animal Health, when they issued guidance around the General Food Law regulation, and made absolutely clear in that guidance that unacceptability is the key test for whether food is unfit for human consumption, and that it's possible for food to be unfit even if it doesn't pose a risk to human health at all. And they give the examples of fingernails in sausage rolls, which is obviously very unpleasant, but isn't necessarily going to do you any harm, or decomposing fish with a strong smell. They also say that food that's unfit for human consumption can include those categories of food where there's contamination, and that contamination means that it will only be injurious to health at a certain level, but nevertheless the contamination itself will mean that it's unfit. And they give there the examples that the FSA gave in the rapid risk assessment of mould in food, but also things like parasites and non-pathogenic microorganisms. And I would also just add to that list that it's possible that food could be considered unsafe within the meaning of the regulation, even if not technically injurious to health, because of the provisions in the Food Information for Consumers regulation relating to use by dates, which says that essentially if you have to use a use by date because a food is highly perishable, after that use by date has passed, the food shall be deemed, i.e. considered at law, to be unsafe, regardless of whether there is actual evidence that that food is going to cause injury to health. Now, the EU legislation does, of course, still apply in the UK post-Brexit because of the grandfathering provisions around the time of Brexit, and the enforcement of those provisions in the UK is enabled by the food safety and hygiene regulations in the UK, which make it an offence to breach certain provisions of EU law, including that overarching obligation under the general food law regulation that you cannot place food on the market if it's unsafe, and food's unsafe if it's injurious to health or unfit for human consumption. And what that regulation does is it sets out the penalties that are applicable. It sets out that in serious cases where an offence is tried on indictment in the Crown Court, there is potentially imprisonment up to 2 years imprisonment, as well as the fine that also applies on summary conviction. And it also confirms that a director or another officer of a company can be liable for that offence if it's proven that that offence was committed by the company with the directors or other officers' consent, connivance or neglect. In addition to that offence under the food safety and hygiene regulations, as Richard mentioned, there is also the pre-existing framework within the UK under the Food Safety Act 1990, which can apply to adulteration because it covers food not of the nature, substance or quality demanded by the purchaser. But it's also worth, I think, just reflecting on the fact that that Food Safety Act does already include a definition of unfit for human consumption, which is more specific than the EU General Food Law regulation, and specifically relates to products derived from animals slaughtered in knackers yards, or in Scotland otherwise than in a slaughterhouse. So that means that in the UK, those products specifically are unfit for human consumption, as well as those where the General Food Law regulation says that they are unacceptable for human consumption according to their intended use because they are contaminated or putrefied or have deteriorated or decayed. And as with the food safety and hygiene regulations, offences under the Food Safety Act are punishable by a fine, and there's no limit in the legislation on that fine, just as with the food safety and hygiene regulations. And again, they also provide that there can be director or officer liability with consent, connivance and neglect. But the good news for food business operators is that although the food safety and hygiene offences, both in relation to non-compliance with the EU framework, but also in relation to non-compliance with the Food Safety Act and the misleading and nature, substance and quality offences, is that although they're strict liability, so a prosecutor wouldn't have to prove that you intended to breach those requirements, there is a defence available. And that defence is essentially what we call a due diligence defence, which means that if you can show as a business or indeed as an individual, if you're proceeded against in that way, if you can show that you took all reasonable precautions and exercise due diligence to avoid committing that offence, or indeed to avoid your employees under your control committing that offence, you will be not guilty of that offence. Now, exactly what amounts to due diligence will be different in every case. It's very much a fact-based offence. An old trading standards case confirmed that the courts would look at costs and business practicality, as well as the actual risk of injury that's involved in the case. But it's a very helpful to know that the systems that you're introducing can help you if you fall to be a victim of fraud higher up the chain in terms of having those systems and checks in place. The fact that what's reasonable in each case is dependent on the case itself and the facts of a particular business is also confirmed in the Food Standards Agency guide on the Food Safety Act, and that guide also explains that it's the burden of proof. The burden of proof is on the person accused of that offence. So what that means is that if you're accused of breaching that overarching EU obligation not to place unsafe food on the market, or one of those Food Safety Act offences, you have to show that you had all reasonable precautions in place. It is up to you to prove that. It's not up to the prosecutor to prove that you didn't. Now, if there was another horse meat star scandal 10 years on from 2013, I think it's worth remembering in the context of those offences that both the Food Standards Agency or Food Standards Scotland, who have responsibilities for enforcement over certain types of food business operations, and local authorities who deal with enforcement action for other types of food business operators, have enforcement approaches depending on which are governed by the principles of the Enforcement Concordat. And the Enforcement Concordat sets out that regulators must take into account proportionality. They must take into account consistency so that they're sending a clear message. They must be open, they must be helpful, and they must have a clear complaints strategy, which means that really regulators are encouraged to only take enforcement action in those serious cases where it's proportionate to do so, or in cases where control measures aren't in place, which again leads to it being proportionate to take action. And against that, those overall principles, it's worth considering that since horse meat, we do now have a new food crime unit, which has been established by the Food Standards Agency in the UK. And it was set up in 2015 following the Professor Elliott review of the horse meat incident. And that unit is tasked with protecting consumers and the food industry from food crime within supply chains. And food crime is defined as serious fraud and related criminality. So this isn't accidentally mislabeling something. This is seeking to obtain financial advantage dishonestly through selling food essentially as something other than what it is. And the FSA gives some examples on their website of food crime, such as the use of stolen food in the supply chain, unlawful slaughter of meats, diverting unsafe food, as well as adulteration, which we saw in the horse meat scandal, substitution, misrepresentation of foods, and also document fraud. And the Food Standards Agency say that the National Food Crime Unit response, so their enforcement approach, will be decided based on how serious the fraud is, how much it has been planned and coordinated. So essentially, whether it's premeditated, whether it's organised, and also the impact of that fraud, not only within the UK, but also across boundaries, and the financial loss and harm to the public and to industry accordingly. And in connection with those aims, they've set strategic objectives which are set out on the slide. And I think the inclusion of inauthenticity as well as unsafe food perhaps demonstrates that unfitness and food that's not of the nature, substance or quality demanded, as well as misdescriptions, will be just as much a target for enforcement by the National Food Crime Unit as food that is likely to cause injury to health. And as it says on the slide, that the FSA have developed a self-assessment tool for businesses to help assess their resilience to or vulnerability to that food fraud. So, as Richard said, it's important to look to the future, and as well as the impact of Brexit and COVID, I would encourage all food businesses to keep an eye on what the Food Crime Unit are saying are their enforcement priorities, and where they've identified that there might be risks of threat in terms of the food that is being supplied to us. And there's a couple of really helpful places to do that. First of all, in 2020, the Food Standards Agency issued a strategic assessment, and that strategic assessment identified a number of risk areas in terms of products and sort of general ability to commit fraud, where there could be threats to the UK supply chain. And top of that list was red meat, where the FSA said that risk points include things like livestock theft, the entry of meat from stolen or illicitly slaughtered animals, right the way through to adulteration and misrepresentation and identification issues, although they did say in 2020 that their data showed low levels of species anomalies within larger supply chains. But they also identified products such as fish with concerns around speciation, particularly whitefish, eggs, where misrepresentation of date, quality and provenance is potentially financially lucrative, shellfish, because that can be subject to illegal harvesting and misrepresentation of quality, and alcohol, particularly around spirit drinks being adulterated with industrial alcohol, as well as those more general crime risks identified in that threat assessment, such as marketing substances which are unsafe for consumption at all. And they gave the example of marketing products as having fat-burning properties, products which command a higher value, such as olive oil and herbs and spices, misrepresentation of premium status, diversion of waste products, such as animal byproducts and products intended for destruction, and the possibility of fraudulent and unsafe products being sold online. And that was followed, that threat assessment was followed in 2023 by the National Food Crime Unit itself publishing their control strategy. And within that control strategy, there were several priority areas identified to run through to March 2024, and they're detailed on the slide. Some of those are the same as the threats that were identified in 2020. But the last one on the list, sustainable products and claims, that's quite an interesting one, I think, because that isn't something that received particular coverage in the threat assessment in 2020. But it is an area where we've seen other authorities focus. And by that, I mean issuing of guidance by the Competition and Markets Authority around green claims, action taken by the Advertising Standards Agency against products where they consider that claims made as to environmental credentials not being properly substantiated. So that does seem to be a real sort of area of focus at the moment in terms of how food is represented. And against that sort of background and outline of threats and priorities for this year, I think we should take into account that the FSA and the FSA officers are signatories to the Enforcement Concordat, so need to act proportionately and consistently, and that they have a manual of official controls which sets out to officers that they should take enforcement action based on risk, as set out in the relevant General Food Law regulation, and take into account what is appropriate. And that leads on to the Manual of Official Controls, saying that officers should consider the hierarchy of enforcement measures, and not necessarily moving straight to prosecution where food is unfit, or where it breaches one of those quality requirements, but potentially taking advice towards the top of that hierarchy of enforcement, being sort of verbal advice or informal advisory letter, depending on the urgency and the severity of the situation, the most appropriate course of action to control the risk, and the enforcement tools that are available under the piece of legislation, but also taking into account the history of the food business operator and their willingness to comply. And we see a very similar picture for local authority enforcement officers as well, in terms of requirements upon them to take into account that hierarchy of enforcement, to consider under the Food Law Code of Practice whether what they're going to do is proportionate and reasonable, and also to consider whether they have evidence that an offence has been committed, which of course takes into account whether you've got reasonable precautions in place, such as are likely to amount to due diligence, and to take into account public interest. But it is just worth pausing there to say that we are about to see a change in terms of local authority enforcement in the UK, because the new Food Law Code of Practice includes a new model for delivery of food standards controls, where where officers are going to be moving away from periodic inspections that apply at a certain frequency for all food business establishments, to something that is based on a risk assessment carried out by the local authority as to the inherent risks of a business and their compliance records and systems, which determines how frequently they'll be inspected. And for those very low risk businesses, or at least those businesses that the local authority consider a low risk, they may actually never be inspected. They may only have alternative inspection arrangements, which could include remote arrangements for checking their systems and so on. But although we are looking at a proportionate enforcement regime, overall, it's worth bearing in mind that if you do commit food fraud, if you're found guilty of selling unfit food or food that breaches one of those other offences, sentences are going up within courts. The sentencing guideline that was introduced in 2016 includes provisions for courts to go up to £3 million, and the culpability of the business and various factors as to whether the business has a good record or not are very important in that. There are definitions of what's high culpability and what is low culpability for those purposes, very much setting out that systemic failures within an organisation come within a definition of high culpability, particularly if you're not putting in place recognised standards and are ignoring messages you're receiving from regulators. And this table is an extract from that sentencing guideline and shows that there is a really massive difference, something like 15 times for an offence for a large organisation. For a harm category 1, so that's a high risk of harm. If you've got low culpability, you're looking at a starting point of £35,000. But if you've got high culpability, you're looking at a starting point for the fine of £500,000. So a very significant difference. And there are various factors that can move you up or down from those starting points accordingly. We have seen numerous prosecutions reported in the press for food safety offences and for unfit food. There's some examples on the slide which, because of time, I'm not going to spend too much time going through, but I do particularly want to flag the Tesco case in 2021. Which was a record fine for a food safety offence, and Tesco were fined over £7 million for having out-of-date food on display, despite the fact that there was no evidence that that food was actually injurious to health. The court were taking into account there that deemed unsafety provision under the Food Information for Consumers regulation, where a use-by date has passed. And the other one that I just wanted to mention is one that was reported this year around a prosecution in Southwark for, as the Daily Mail calls them, the food fraudsters. Who had taken meat that was intended for animal feed and sold it for human consumption. The investigation by Southwark followed a tip-off from the National Food Crime Unit to the local authority officers, showing that the National Food Crime Unit really are trying to focus on those instances where there is criminality involved. Finish up, it was really just to say that in terms of where we are now, 10 years on from horse meat, I think what that really means is that the likelihood of enforcement is very likely to depend on what steps a business is taking itself to ensure that they comply with food laws and they detect the possibility of food fraud in their supply chain. But if you do get it wrong, then fines can be significant. Thank you.
Thank you so much, Richard and Nicola, for such interesting and engaging presentations. And I think sort of, we're just scratching the surface of the discussion, because there's obviously the FSA consultation around providing the Food Crime Unit with powers of entry under Section 18 of the Police and Criminal Act, which would give them more teeth. And there's a lot more going on in this space. But unfortunately, we've run out of time. So I'd like to thank everyone for attending the webinar today. And what I would ask is, if you have any questions, what you do is contact the speakers directly. The details are on the screen now. We will share a recording of the webinar, including in any Q&As that come about after a session, and to everyone who attended today via email and online at our webinar hub, which is ifst.org/webinars. Before you log off, please fill in a short survey, which will launch after the webinar ends. And thank you so much again to everyone for attending today. Really appreciate it. Have a great day and goodbye.